Page wise adjournments. Page number 1, cell number 1. Page number 2, cell number 2 to 7. Page number 3, cell number 8. Cell number 8 to 13.
Serial number 12 minutes. Serial number 12 minutes. Proxy council minutes. The council on record is not well. It's spread for 1 week time for compliance.
A week's time is granted for complying the office objections, or else the petition stands without
Alright.
further reference to the court.
Like,
Yes.
Page number 4, cell number 14 to 19.
Everybody can do it. Please don't mention. Let it reach. Yes.
Page number 5.
Don't call these orders matters. After that, from interlocutory, you please call.
Page number 9, cell number 40 to 45. Page number 10, cell number 46 to 53.
Let's serial number 47. It is yesterday's matter alerts. This was listed, supposed to be listed on 14/11. Now it is listed for dismissal minutes. Yesterday it was adjourned to 14/11 for compliance of office objection.
Look at it. 47, 46. It is adjourned to what date?
14/11. However, in minutes I may be permitted to comply with office objection.
14/11. Then counsel the petitioner submits that the matter is wrongly listed in the caption for dismissal. Already this court yesterday had granted time till 14th for complying with the office objections. The petition is permitted to comply the office objections. Give the file to her. Yes.
Let's, in fact, instead of adjourning minutes, I am filing a memo. I'll comply the office objection minutes by the time it reaches. It may be disposed of minutes since the suit itself is disposed of.
Pass over. Pass over. Pass over.
Serial number 43, mother.
Serial number?
43. The matter is settled between the parties.
Take that from. A memo is filed stating that the issue is settled between the parties and they have entered into a compromise before the local Adalat. Hence, nothing survives for consideration in this petition, accordingly dismissed as instructions. The memo is taken on file. Yes, next. Next.
Page number 11, cell number 54 to 59.
serial number 57 58 months. They have it next. The council for the appellant is not keeping it. 57.
Inform the other side.
I have already informed.
And counsel, it is submitted at the counsel, the petition is not feeling well. This is matter on 20th. Yes.
Serial number 58, madam. For the petitioners, matter has been already referred to mediation. Some progress is One second, madam. Take a chance.
This is matter is submitted that the mediation is going on and there's a likelihood of settlement. This is matter on 3rd of December.
This is serial number 56 for the respondent on behalf of Santosh Dharwad. We will take a next week some
Right.
personal inconvenience. I will inform the other side, madam.
At the request of the counsel, the respondent, this is matter on 19th.
Please.
Yes.
Page number 12, cell number 60 to 63.
Serial number 61, members. I appear for appellant. The counsel for appellant father has died, my lords. The 25th, my lords.
At the request of the counsel, the petitioner, this is matter on
5th.
25th.
Interim order kind.
Intermod early granted is extended till then. Yes. Yes.
Page number 13, serial number 64 to 69.
Even to 67 minutes, I request for a week's time minutes. I need to receive certain documents in that.
Every matter for no reason is being adjourned, and by that day, the date matters itself are running into. This is matter on 25th, no further adjournments.
Madam, serial number 64.
Hmm?
64. And for the respondents, madam, I'm
64. Why not today?
we don't have instruction from the client.
What instructions you want from the client? List this matter on 13th at the request of non-counsel, the respondent. Have you informed the counsel for the petitioner? No.
Yes, without vote.
No, don't adjourn this matter. Please inform and come back.
Well, it's 67 minutes instead of 25th. Next week, any date. 25th, marriage is there.
20th,
Please, madam.
list 2067 on 20th.
28.
Yes, next.
Page number 14, serial number 70 to 75.
Serial number 71 minutes. I appear for petitioner. There is another CP pending before this honorable court, which was listed day before yesterday, wherein matter is referred to mediation, which is listed on 19th before mediation. Now, kindly have it on 22nd.
At the request of non-counsel, the petitioner list this matter. Inform the other side.
I have informed.
This matter on 22nd.
No, it's interim order granted earlier. May kindly.
Interim order earlier granted is extended till that. Yes.
Please, ma'am.
Page number 15, serial number 76 to 78.
My lord, serial number 77, on behalf of the petitioner, seek for a week's adjournment.
70?
7.
77.
Why? It's not even,
Actually,
it has to come for
CS
hearing.
Setter was supposed to hear the matter, because his name is appearing for the petitioner also. He's out of town. Maybe can you put on Monday or Tuesday?
List it on Monday at the request of non-counsel, the petitioner.
Page number 60, serial number 79 to 87.
Milord, serial number 79, petitioner has died, Milord. Milord, it is RPFC, Milord. He is the husband. I'll seek necessary instruction, Milord.
Then what remains for consideration?
Milord, today only I have received
Be
information.
submitted, but that the appellant is no more. List this matter on 26th of November for taking steps.
82 milords. May I request on Monday, milord?
It's a CP, why you
Milord,
want?
yesterday it was listed. The lords asked me to verify the stage of the milord proceedings.
So that can be done online.
The milord online, milord is not coming. I'll check by the afternoon. If I come to know, milord,
That will pass over, please come.
please.
Yes.
My lord, serial number 87, my lord.
80?
87, my lord. I'm for petitioner, my lord. Senior is not well, my lord. Kindly post the matter next week, my lord. Kindly extend the interim order, my lord.
Either you can have adjournment or argue. You can't have both. This is matter on 25th of November, interim order granted earlier. Have you informed others? Not informed. Please, please make a note, code officer, on the cause list that
My
without
lord,
making informing the other side, no mention shall be made. Please come back after informing them. Yes.
Much.
Yes.
Page number 17, serial number 88 to 90.
Lord, serial number 91, appearing for petitioner, Lord. Request for weeks accommodation.
Why?
Some personal inconvenience.
You are the counsel now? Counsel appearing?
Counsel appearing for petitioner. Some personal inconvenience. I informed the other side. 13th May.
No, there should be. What is the personal inconvenience? Please set the point. You're not. You're come to the court. You're arguing the matters.
Some
What some inconvenience?
13th May.
I do not expect advocates to seek adjournments like this. Or 2023 CRPs, you obtain interim orders and you.
Interim order is not obtained.
Then we'll list this matter after next year. List this matter in the month of December 2020, December 20th. Yes.
Serial number 73.
Yes.
73, ma'am. Counsel for the petition of some inconvenience. Kindly have it on 12th or 13th.
List this matter on 13th.
Much.
No mentionings in orders.
Not in station. Informed other side also. Today, in fact, we moved for not to post scholarship, but the matter is okay. 28. For respondent is out.
28 office objection shall be complied by 12th of November, or is by 13th of November, or is the petition shall stand dismissed without further reference to the court. Call the list.
Number 1. Order notice, serial number 1. Equipment matter.
Ask this, what is the status of my lord? Order came to be passed on 5/9/2017. The certified copy I obtained is that my lord on 2019.
I had taken the status.
No, latest one.
Same status is there, my lord. It was dismissed 4 weeks time.
No application is filed
No
there.
application.
That minutes I have asked my counterpart advocate to ascertain. The lordship may have it.
You should have it by this time.
Like
It's not a
was-
big deal. And whatever that online case status shows, that will be there. The Supreme Court case status, every application you file, that reflect. We don't require any instructions on that.
That I have asked my counterpart advocate.
No, that's what I'm saying. Your counterpart need not tell you everything. Every application you file, even before this court also, it will be reflected.
True.
Let's not keep it pending a CRP of 2012. Please argue.
Execution dismisses my petition. So as sought for a permanent injunction has been decreed in OS number 104 of 74 minutes.
OS number
104 of 74.
104 of 74.
1974.
Decreed on
Decreed on 22/6, 1997.
1974.
1974.
Hmm.
When they started interfering with my lord, I have presented this execution petition. The trial court, the executing court dismisses on the ground. In the intervening time, my lord, he files one suit 118 of 2001.
OS 118 of
Of 2001. Present judgment letters.
118 of
2001.
2001 seeking declaration.
Declaration that the judgment and decree obtained in the earlier suit is null and void, and the sale deed which has been executed in their favor is crossed.
So then what happened?
The suit came to be decreed.
On
28/9 and 2006.
28/9/2006. Thereafter,
Against that, I had preferred an appeal. Appeal was allowed.
what is the number?
My lord, RA number 89 of 2006,
It was allowed.
which was allowed on 15/9/2010.
59.
2010.
No.
Against that, the plaintiff preferred an appeal. That is RSA 5953 of 2010,
RSA.
5953 of 2010. That was dismissed.
On
4/4/2014.
4
4/2014.
4/4/2014. No.
My lord,
Against that, he filed SLP.
yes, sir.
Number? Give that.
I will pass on. The petitioner granted 4 weeks time to cure the defects pointed out by the registry in the office report. Otherwise, the special leave petition stands dismissed without further reference to the court. Any application for restoration shall be entertained only on payment of cost to pay Supreme Court Legal Service Authority.
No, this is
the order
dated 5/9/2017.
17.
Then when is your EP?
Please, madam.
EP is on 2011.
2011.
So all these have no nexus with your EP.
Please, madam.
EP is of the year 2011.
11.
Dismissed on
Dismissed around 24/2012.
24/2000. Something you don't know.
And the reasoning is on
Page number.
page
Let's read from 7.
paragraph 7.
Yes.
This court perused the material available on record. It is not in dispute that this court has passed a decree for injunction restraining the original judgment debtors from interfering in the possession of the original decree holders in the original suit. So number 104, my lord, by its judgment and decree dated 22/6/1974. The present decree holder Basavanappa is original 20 of the original suit number 104 of 1974. It is not also in dispute that against the judgment and decree passed in original suit number so and so. The present judgment letters filed an original suit OS 118 of 2000. Said suit 118/2000 was decreed by the additional senior civil judge court at Nada, Bangalore, holding that the present judgment letters of the owners and possession of the suit property herein. Therefore, it has come clear that by virtue of the judgment and decree dated 29/2000 passed in the original suit 1182, the present judgment debtors were in possession of the suit property, but the present decree holders have not shown as to when they came in possession of the, after the FTC court Ranebennur set aside the judgment and decree passed by the senior additional civil judge court Ranebennur RA number 18 of 2005 judgment dated 15/9/2000. Therefore, out of the material available record from the date of filing original suit till the judgment and decree passed in suit, it is set aside that FTC so and so by judgment 15/9/2010. That is, during the subsequent proceedings and the present DH have put in possession of the suit property of this case, beside the present judgment debtors, one year is not a party to. Therefore, the present execution petition cannot be filed on their behalf as they were not parties to the original suit. The present judgment debtors were in possession of the suit property. As discussed above, the present decree holders have not shown the fact that on this date of 15/9/2010, the present judgment debtors were dispossessed. Therefore, in the considered opinion of this court, in view of the subsequent passing of the judgment and decree passing of original suit and regular appeal, after passing of the decree in original suit, this court is of the opinion decree holders will prove that the relief sought to be granted as sought by them. Moreover, there is no oral and documentary evidence to prove the fact that the decree holders is in possession of the suit property as on date of the filing.
Come to para number 10.
Moreover, the decree holder himself in the scheduled enacted petition at para number 4 specifically stated there is no obstruction by the judgment debtor. Debtor number 1. In view of one admission, decree himself in the present petition, there is no obstruction by the defendant number 1 judgment. An inference can be drawn that there is no obstruction all by the defendant number judgment debtors. When there is no obstruction by at all by the defendant of the judgment, as on why the present is filed by the decree holder is not explained, then there is no obstruction by the defendant judgment debtor. Hence, there is no question of granting relief as sought by the decree holder in the present petition. In the present petition, it is contended that the Honorable High Court Circuit Bench at Dharwad has rejected the state.
Yes, what do you say? No, there is a judgment and decree in their favor as far as your suit is concerned, and the question of the court deciding after the judgment and decree in your case, how when he is put in position and all immaterial things. What remains is now there is a decree in his favor. You do not have anything. Whatever that is there is suspended.
Is that my dismissal of my appeal before this honorable court?
No,
they have
the
preferred
question
appeal.
of no. When a suit, when judgment and decree is granted in favor of them, when the suit for injunction.
In fact, that decree will also the present the respondents or challenge that decree obtained by him.
Nothing
And
has
that
happened.
is not binding.
That is no, it ended up in dismissal now.
Of course, it is ended up in
Ended up in dismissal? Ended up in dismissal? No, even viewing it at this point of time, like all these things or the subsequent changed circumstances from the date of order, viewing it as of now, why is he not entitled for it?
My only submission is that since SLP is pending before the honorable court, so we cannot.
Unless until there is an order that we cannot consider. Please come.
Just narration of the facts, my lord, the judgment of this court has narrated everything. What all transferred it will be there.
You have that order? No, he's having it. You have a copy of it. You're showing it.
Our second appeal is tagged with this case, my lord.
He has a copy. Which para?
Paragraph number 3, my lord.
Paragraph number? 3. Yes.
A suit has been by the OS 1 against one of the present judgment debtors.
No, you're saying that all these facts are narrated.
No, not regarding what has been transferred on the 104 after institution of 104 original suits and 118 of 2007.
Come to the relevant para.
They said that we are in possession of the property.
Where is that particular finding?
number page 10. Similarly, defendant non-occupied also filed a written statement. My lord got it.
Para number 4.
Para number 8, last concluding page number 10. Similarly, defendant non-occupied also filed a written statement admitting the execution of a sale deed dated 16th and possession being handed over to the purchasers.
Similarly, defendant number.
So they delivered possession. I am in possession of the property.
Please come. The present petition is filed. Agreed with the orders passed on EP number 34 of 2011 on the file of the principal civil judge and first additional JMFC. How do you spell this? Rane Benor. The petitioner herein is the decree holder. He had filed OS number 104 of 74, seeking the relief of permanent injunction against the defendants. That suit came to be decreed on 22/6/1974. Thereafter, the defendants in OS 104 of 74 have filed OS number 118 of 2011, stating that they are the owners of the property, and sought a declaration that sons of the original defendants in OS number 104 of 74 has filed OS number 118 of 2011, seeking a declaration that the judgment and decree in OS number 104 of 74 is not binding on them, and the sale deed that is executed by the father in favor of the plaintiff in OS 104 of 74 is also not binding. By filing OS 118 of 2001, that suit came to be allowed on 28/9/2006. Agreed thereby, the defendant therein, who is the petitioner herein, had filed RA number 89 of 2016. That came to be allowed on 15/9/2010.
16.
15/9? You said 10, 2010. RA.
Correct.
15/9/2010. Then the plaintiff had carried this matter in further appeal by filing RSA number 1953 of 2010, which came to be dismissed on 4/4/2015. It was the plaintiff had filed SLP number 3303 of 2015. On 5/9/2015, an order is passed wherein the plaintiffs are granted 4 weeks' time to cure the defects pointed out by the registry in office report. Otherwise, the special leave petition shall stand dismissed without further reference to the court, and any application for restoration shall be entertained only on payment of costs of ₹1,000 to be paid to the Supreme Court Legal Services Company. It appears that even till now, no application is filed to restore the SLP. The next one. In the year 2011, EP is filed by the petitioner herein, who is the plaintiff and who is the decree holder in OS number 104 of 74, seeking execution of the decree. By order impugned, the trial court had dismissed the application filed by the decree holder. The reasons that are given by the court are that the decree holders have not proved the fact that on which date after 15/9/2010 the present judgment debtors were dispossessed In the considered opinion of the court, in view of the subsequent passing of judgment and decree in OS number 118 of 2001 and regular appeal in 89 of 2006, after passing of the decree in original suit number 104 of 74, the decree holder has not proved that the relief to be granted as sought by him. The court comes to the conclusion that there is no material on record to prove that the judgment debtor is in possession of the property. And further, court observes that it is admission of the decree holder himself that the judgment debtor is not obstructing the
First judgment. First judgment.
that there is no obstruction at all by the first judgment debtor. The court observes that when there is no obstruction at all by the judgment debtor number 1, but then what is the reason for filing this application is not mentioned. The court also observes that in RSA number 5953 of 2010, the High Court had rejected the state petition filed by the judgment debtor, but the decree holder has not produced the order of dismissal of state petition by the High Court. As such, the court is of the view that the decree holder has not proved sufficient grounds to grant the relief as sought for in the present petition, and accordingly dismiss the petition. Next paragraph. Learned counsel appearing for the petitioner submits that the reasoning that is given by the court while dismissing the EP filed by the decree holder is contrary to law as well as contrary to the facts. When the defendant, when the suit filed by him is decreed, holding that by granting the relief of permanent injunction, the court has given a categorical finding that the petitioner is in possession of the property. When the other suits, the other suit, that is OS number 118 of 2011, was decreed on 28/9/2006, and immediately RA was filed on RA 89 of 2006 is filed, and that came to be allowed on 15/9/2010. The court, on the ground that in RSA, the state petition was dismissed, the court having given a finding that in the RSA, state petition was dismissed, still on the ground that the copy of the same is not filed before the court, that cannot be a reason for the court to hold that the petitioner is not entitled for the relief. Learned counsel submits that court has misdirected itself in giving such a finding. Full stop. Further, learned counsel submits that in the light of the subsequent dismissal of the RSA and also the SLP not being restored, which is of the year 2015, he submits that as a decree that is passed in his favor is staring at the defendants. They are bound by the said decree, which has attained finality, and it's the duty of the court to execute the same. Next paragraph. Learned counsel appearing for the judgment debtor submits that he is yet to get the instructions from his counterpart appearing before the apex court. He submits that the said judgment is not binding on them, as they were not parties to the judgment. In fact, it is the father of the judgment debtor who is a defendant in the suit. It is submitted that the court had rightly considered all the aspects, and particularly the fact that there is no evidence to show that they are in possession of the property. Property Court had rightly dismissed the petition, and there are no grounds made out seeking interference with the well-considered order passed by the court. Next paragraph. Having heard the learned counsels on either side, there is a material on record. The undisputed facts in this case are OS number 104 of 74, which is decreed on 22/6/1974, granting a decree of injunction against in favor of the petitioner herein and against the father of the respondents herein and father of the respondent or anybody representing through him. It is also undisputed that the declaration suit that is filed by the respondents herein came to be, as of now stands, dismissed as the SLP, as per the case status as on today, is not restored right from 2015. Without going into any of the merits of the matter, there is no hurdle for the trial court to execute the decree, as the only judgment and decree that remains to be there is the judgment judgment and decree that's passed in OS number 104 of 74, dated 22/6/1974. In that view of the matter, the order impugned dated, what is the order date?
20th April 2012.
20th
20th April 2012.
20th April 2012 is set aside, and the court shall pass appropriate orders in the application filed by the NITX number 34 of 2011 within a period of 3 months from the date of receipt of the copy of the order.
It has to remand it. Execution petition has been disposed. It has to be remanded to.
That's what remand. Set aside and remanded. And 3 months it has to be decided.
Date may be given
I said to appear
to appear.
without further notice to the parties. Parties shall appear before the court on 25th of November.
Suit for declaration and possession.
Use the mic. Yes.
Suit for declaration and possession, my lord, was concurrently declared. Pursuant to that, my lord, execution petition was filed, my lord, that came to be dismissed.
You're the petitioner before this court is?
Suit for declaration and possession.
You are the
Petition.
petition is who?
Plaintiff, my lord.
Petitioner is the plaintiff.
Yes.
What is the impugned order?
My lord, impugned order, my lord, my execution petition came to be dismissed.
Yes. Or you said what is the suit for declaration?
Declaration and possession.
When was it decreed?
Five, 23/7/2005.
23/7.
2005.
Against that, no appeal is filed.
Appeal was even appeal.
What is the appeal number?
77/2005.
This is OS number?
It was OS number 82/96.
Huh?
82/96.
Then appeal
RA 77/2005.
70
7.
by of 2000.
5.
What happened to this?
To upheld the order of the Honorable Trial Court.
That is, appeal is dismissed. When?
Dismissed.
Dismissed when? When?
7th September 2009.
7 September 2009.
Please.
Thereafter, no further appeal.
No, madam.
So it has attained finality.
Please.
Then when is your EP?
It was preferred.
Four of 2010.
4 of 2010. It was dismissed by order dated
16/7/2005. 15.
Please come to the Your Honor.
Page number 19, paragraph number 12.
Para number?
12, paragraph 12 of the appeal order, page number 19.
Please read.
The same date produced by the decree holder, that is the exhibit P9, is clearly reveals that the decree holder had taken the possession of the suit property or property mentioned in the same deed on the date of its execution itself. It means the decree holder had obtained the possession of the property mentioned in the same deed on the date of its execution. Exhibit P9 further reveals that the property number 131.3 of 2 is totally measuring east plus 51 feet and north south 45 feet in this extent. East west 10 feet and north south 12 feet was the tailed house. On perusal of the petition averments, it is not disclosing the measurement shown in the exhibit P9. In other words, measurement mentioned in the petition is not matching to the measurement mentioned in the sale deed or in the exhibit P9. The PW1 has admitted in the cross-examination that he had purchased the east-west 27 and north-west 31 in the property, number 131. Except to this extent, he had not purchased any extent of the property. The PW1 further admitted that, so the version of the PW1 has not corroborated with the documentary evidence. The PW1 further admitted that he does not know what were all happened in the original suit number 82/96. The PW1 further admitted that he had obtained the power of attorney from the plaintiff of OS 86/96 by giving assurance of the recovery, the possession of the property, and on the same strength, on the same manner he had appeared in RA 77/2005. As I mentioned above, the recitals of the exhibit P9 clearly goes to show the decree holder had obtained the possession of the property mentioned in the sale deed on the date of its execution, and also the measurement mentioned in the petition is not at all compared to the extent mentioned in the sale deed or exhibit P9. If the decree holder had obtained the possession of the property mentioned in the sale deed, means seeking of actual possession of the property from the judgment letter does not arise. The attitude of the decree holder is clearly discloses that he has come to the court not with the clean hands. The petition averments recitals of the sale deed and the version of the PW1 in the cross-examination is not similar. It is further relevant to note that the original plaintiff of the OS 82/96 has given an affidavit that he has not executed any sale in favor of the present decree holder.
No, the court has to make necessary efforts for identifying the property, what is the suit schedule property, what is there on the picture, without doing anything, just like that, passing an order.
Only 3 submissions are
Yes.
confirmation. Well, first of all, the exclusion petition is not contained without including the original plaintiff, that is Nazir Ahmad. According to him, he has purchased from the Nazir Ahmad. Nazir Ahmad, exhibit D5 has filed affidavit stating that I have not executed any sale deed. He has created on the basis of the power of attorney. Executed in favor of.
That's altogether, because that's accepted, it's altogether
That's
different.
right. Later, in 2011, he has cancelled the power of attorney. We don't know whether that is continued by the other person. On the allegation that he has misused the power of attorney, he executed the sale deed, confirmed sale deed himself. That is one aspect. Therefore, the first submission, without including the original plaintiff, that is the owner of the Nazir Ahmad, the execution petition is not. So far as the second submission is that section 47 of the CPC, the executing court, after considering the documentary evidence, that is the sale deed produced by the petitioner hearing, and the sale deeds of the respondents, and also taking note of the affidavit filed by the original plaintiff. When the original plaintiff filed an affidavit, you could have immediately implemented in the execution petition. There ends the matter. Because without implementing a Malad, it will Malad create a complication. He will say that Malad the R is evidence, that Malad otherwise he will take a separate steps regarding cancellation of saving. That's a different aspect. Therefore, Malad, under section 47 of the CPC, the executing court after Malad considering, after inquiry, after considering the oral and documentary evidence, Malad has rightly Malad rejected his execution petition. It doesn't say Malad it is totally barred. He can file a Malad with a better measurements or better Malad boundaries. That's it.
No, suit is decreed. It has attained finality. You are a judgment debtor. You at any point of time, you have not disputed about the what is the suit scheduled property or what your purchase.
No, yeah.
That what is there on land is not what is there on that. So now there is a decree staring at you. Now if any measurements or any other issues are there, the court could have appointed the court commissioner or some surveyor or somebody to look at it, whether it is it has to at least see whether that decree can be, how it can be executable. Sitting in the court, you cannot look at two documents and compare it.
No, therefore, Malad, the original.
Why is it necessary?
Because
Documents will speak.
The person who has Malad alienated the property.
It is not for him. No, there is a decree, there is a paper. For example, the original vendor died. So that means that you cannot execute the decree.
No, I'm not saying that Malad that is. But so far as to clarify the Malad the decree or the identity of the property.
It can be like how the court did it. If you do it in an execution sitting in the court, some possible effort should be made.
No, because they are not Malad sought for any Malad appointment of commissioner or surveyor.
So court could say as well that with all this it's not possible. Just like that, no, decree is not a paper decree. It should be executed. One has to look at it and the ways and means to execute it. This is not the way. Just like that, we'll ask a court to appoint an advocate commissioner and then whatever, or not advocate commissioner, that to make efforts to see that what is physically what is there and how it can be executed.
Because in the submission that Malad, since the executing court has Malad has gone into under section 47 of the Malad.
Where do you find that it has gone in under section 47?
No, because it has considered the Malad the sale deed. Because the sale deed Malad pertains to the Malad the petitioner hearing. It has gone into the Malad the sale deed. Therefore, Malad the scope of the Malad the revision is very limited and Malad,
no, we will set aside this order. We will set aside this
order.
order.
Rely upon full judgment. The lordship's
Please pass on.
Because the cannot reappreciate the Malad the evidence.
We are not appreciating the evidence at all. The reasoning, whether it is a judicial reasoning, is whether it's on the touchstone of the settled law or not.
Because even a different view is possible. Malad, the Supreme Court says that Malad cannot be.
Yes.
First, Malad,
Yes.
2019 you lordship.
Yes.
This court. Para 8 Malad retire.
2019. Yes.
First, directly I will take the lordship without Para 8 your lordship.
Yes.
At the outset, maybe.
Yes, yes.
At the outset, it is to be taken note that the civil division petition before the High Court is not to be considered as in the nature of an appeal. The scope of consideration is only to take note as to whether there is any perversity in the satisfaction recorded by the original court, namely the rent controller, and in the light so as to whether the appellant authority under the statute has considered the aspect in the background of the evidence to arrive at a conclusion to its satisfaction. The reappreciation of the evidence in the civil division petition to indicate that another view is possible would not arise. To that extent, a perusal of the included order indicates that the High Court, in fact, has proceeded as if the entire evidence required reappreciation by it. In that background, what is necessary to be taken note of at this juncture is as to whether the rent controller has considered the matter in its correct perspective by satisfying himself of the bona fide crime as required under Section 10 3 of the 1960 Act, and the hardship, if any, to the parent as contemplated under the clause of the Therefore, even a different view is possible. He can seek for a declaration of this because there is an ambiguity in this sale. Therefore, the executing court has gone into the next judgment also is the same similar. Para number 15. Last.
Yes.
In addition to the nature of proceedings to impede the legal representative of the executive, we find that none of the tests laid down in section 115 of the code was satisfied by the High Court as to set aside the order passed by the executing court. The High Court, in exercise of revision jurisdiction, has interfered with the order passed by the executing court as if it was acting as a first court of appeal. An order passed by a subordinate court can be interfered with only if it exercises judicial jurisdiction not vested in it by law, or has failed to exercise its jurisdiction so vested, or has acted in exercise of jurisdiction illegally or with material legally. The mere fact that the High Court had a different view on the same facts would not confer jurisdiction to interfere with an order passed by the executing court. Consequently, also. Therefore,
Please come. Agreed with orders passed. Huh?
Like of the judgment to demonstrate
Pass.
all this prevents
Para?
23 and 24.
20.
3. This is the 15 of 28. The ratio laid down by the Privy Council in the case of Palestine, Cooper, Arm, Bank, Cooperative Society Limited versus Government of Palestine and others. The Privy Council is further applicable to the present case of the hand, and the President laid down therein also binds this code. The ratio laid down by the Privy Council in the same case has become the broker's test. Class 6 is given after lapse of 7 decades of its announcement. The principles laid down in the said judgment still holds the same. The ratio laid down has been followed by the several high courts in cases related to the conflict between the boundaries and the measurements. When there is an ambiguity in regard to the measurement and the fact that the controversy in respect of the plot, we are of the view that the principle that description by boundaries would prevail over all the descriptions has to be made applicable to the present case on the hand. The service case of site number 74, which has corresponding site CTS number 74, also indicates that northern boundary of the food schedule site number 74 still 20 feet road. When section layout as per exhibit is of site number 74, there is no ambiguity so far as the boundaries are concerned. Note the matter before the hand, so far as OS, RA, execution petition, even if compared to my exhibit, the boundary is intact.
Please come. Agreed with orders passed in EP number 4 of 2010, date 16th July 2015. The decree holder is before this court. The petitioner parent, who is a decree holder, had filed the suit OS number 82 of 96 seeking declaration and possession that came to be allowed on 23/7/2005. The defendant had carried the matter in appeal by filing RA number 77 of 2005, which came to be dismissed by judgment and decree dated 7 September 2009. Thereafter, the judgment debtor, the decree holder, had filed EP number 4 of 2010, which came to be dismissed on 16/7/2015. The reasons given by the trial court for dismissing the petition, dismissing the execution petition file, is that the sale deed produced by the decree holder clearly reveals that the decree holder had taken the possession of the suit property or property mentioned in the sale deed on the date of its execution itself. It means the decree holder had obtained the possession of the property mentioned in the sale on the date of its execution. Exhibit P9 further reveals that the property number 131 ward number 3 at block number 2 is totally measuring east-west 51 feet and north-south 45 feet. In this extent, east-west 10 feet and north-south 12 feet was a tailed house. On perusal of the petition averments, it is not disclosing the measurement shown in Exhibit P9. The court observes that the measurement mentioned in the petition is not at all matching to the measurement mentioned in the sale deed or in Exhibit P9. PW1 has admitted in the cross-examination that he had purchased east-west 27 and north-south 31 in the property number 131. Except to this extent, he had not purchased any extent of property. The version of PW1 has not corroborated with the documentary evidence. PW1 further admitted that he had obtained the power of attorney from the plaintiff of OS number 82 of 1996 by giving assurance to record the possession of the property, and on the same strength or on the same manner he had appeared in alia number 77 of 2005. The recitals of Exhibit B9 clearly goes to show the decree holder had obtained the possession of the property mentioned in the sale deed on the date of his execution, and also the measurement mentioned in the petition is not at all comparing to the extent mentioned in the sale deed. The court comes to the conclusion that he has not come to the court with clean hands. The petition evidence recitals of the sale deed and version of PW1 in the cross-examination is not similar. It is relevant to note that the original plaintiff of OS number 82 of 1996 has given an affidavit that he has not executed any sale deed in favor of the present decree holder. The said affidavit is marked as exhibit in this case. In overall consideration, it appears that the decree holder has failed to prove that, in spite of point number 1, in spite of accusing oral and documentary evidence, and accordingly dismiss the petition. Next part. Learned counsel appearing for the petitioner, decree holder, submits that in RA number 72 of 2015, the petitioner is transposed as the plaintiff. He is substituted in the place of the plaintiff as he purchased the sued property. He submits that just because in the recitals of the said sale deed, if it is mentioned that the possession is given, that cannot be a ground for the court to come to the conclusion that the decree holder has come to the court with unclean hands. By the time he purchased the property while pregnancy of the RA, the suit is filed for declaration and recovery of possession. That itself crystallizes that the proposition is not with the plaintiff, with the original plaintiff who has sold the property to the revision petitioner decree holder, who was substituted as a plaintiff in the RA number 72 of 2005. When two courts have concurrently held that the plaintiff is entitled for declaration and for recovery of possession, court considering the court had not made any efforts to see that the decree is executed in favor of the plaintiff, in favor of the decree holder. And the court considers an affidavit filed by the original owner, that's the original plaintiff, that he has not executed any sale deed in favor of the decree holder. Then counsel submits that, if at all, the sale deed is not executed by him, he has his ways and means to fight this, to approach the court, and that cannot be considered by the court in the execution proceedings. He had relied on a judgment of the the judgment of this court, and a judgment of the division bench of this court in case of Jai Sheila Venu and others versus AJF D'Souza, arising out of RFA number 1225 of 2011. Relying on this judgment, he relied on para number 23 and 24 and 25. Extract these three. Paris. Relying on the said judgment, he submits that court has failed to exercise the jurisdiction vested in it and 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 failed to consider the application on the merits of it. And the same is liable to be set aside. Next part. Land counsel appearing for the respondent judgment debtor submits that the court had rightly dismissed the execution petition. He submits that the decree holder has purchased the property from the original plaintiff. You should have implemented the original plaintiff, and for non-joinder of the necessary party on the first round, the EP is rightly dismissed. He submits that when the boundaries and in the sale deed and the sale deed and the version of the decree holder is not tallying, court had exercised his discretion, and as the decree is not executable, had rightly dismissed the petition. The counsel submits that this court, while exercising the jurisdiction under 115, cannot, if two views are possible, and on that ground, the court cannot interfere with the order passed by the trial court, and the court cannot assume the role of an appellate court. He had relied on the judgment of the apex court in D. Shashikumar versus Soundarajan, reported in 2019, 9 SCC 282. Relied on paragraph number 8. Extract this. He has also relied on another judgment of the apex court in case of Varadarajan versus Kanakavalli and others, reported in 2020, 11 SCC 598, para number 15. Relying on these judgments, non-counsel submits that the executing court has passed an order, exercising the jurisdiction vested in it, and this court exercising the jurisdiction under 115 cannot interfere with the well-considered order passed by the trial court, passed by the executing court. Next part. Having heard the learned counsels on either side, peruse the material on record. The original plaintiff had filed OS number 82 of 96 seeking declaration and possession. That came to be decreed on 23/7/2005. Thereafter, the decree holder had purchased the property by way of a registered sale deed, and he is substituted in the place of the decree holder, in the place of the plaintiff in RA number 77 of 2005. In that appeal filed by the defendant came to be dismissed on 7th September 2009. At any point of time, the defendants, the judgment debtors, have not taken any plea with regard to the nature of with regard to the suit scheduled property, and the fact that it is not tallying, the measurements are not tallying, and in that regard, no issue is also framed by the courts. When two courts have held that the decree holder is entitled for a declaration and also a recovery of possession, the executing court shall make all its endeavor to see that the paper decree becomes a reality. In this case, the court says that if the sale deed that is obtained by the decree holder during the pendency of the RA contains that possession is delivered, as such he has come to court with unclean hands. When the suit itself is filed for declaration and recovery of possession, and when he purchased the property during the pendency of the suit, that the court cannot draw such an inference that when already he is in possession of the property, question of recovery of possession does not arise. The court cannot, when there is a decree of declaration, when there is a judgment decree of declaration and recovery of possession, the executing court cannot go into these kind of things and reject the petition. The court has also considered an affidavit filed with the original plaintiff that he has not executed the sale deed. Even that aspect is also beyond the scope of jurisdiction of an executing court. If he has not executed, the original plaintiff has not executed the sale deed, it is for him to take appropriate steps and file an appropriate application in that regard. Admittedly, in this case, no such efforts were made by the judgment by the original plaintiff. So all those things are not german for consideration for the executing court while deciding the application. The executing court at all times should make an endeavor that the decree is executed in its true letter and spirit. If there is any dispute with regard to identity of the property, the court ought to have taken appropriate steps. Then coming to the submission of the land counsel for the respondent, that this court, while exercising the jurisdiction under 115, that the scope of consideration is only to take whether there is perversity in the satisfaction recorded by the original court. And reappreciation of the evidence in the civil revision petition to indicate that another view is possible would not arise as laid down by the apex court in Shashi Kumar's case, referred supra. This court is of the supra. There is no dispute about, it is settled law, that what is the powers of the High Court while exercising the revisional jurisdiction. In the other judgment, the Honorable Apex Court in Varadarajan's case, referred supra, has observed that an order passed by a subordinate court can be interfered only if it exercises only if it exercises a jurisdiction not vested in it by law, or has failed to exercise its jurisdiction so vested, or has acted the exercise of jurisdiction illegally or with material irregularity. That is broadly the scope of 115, where the powers of the High Court has to be exercised. In this case, the court had failed to exercise a jurisdiction vested in it, and also has gone into certain issues which are not within the scope of an executing court. Under those circumstances, this court feels that this is a fit case where this court has to exercise jurisdiction under 115 CRPC. Accordingly, the order dated 16th July 2015 is set aside, and the court shall is set aside, and the matter is remanded back to the executing court, and the executing court shall hear the petition, afresh, and for identification of the property. If any, the court shall see that the decree is executed, and in that process, if any other steps are required, and the decree holder is at liberty to file an appropriate application, and accordingly, the executing court shall pass appropriate orders within a period of 6 months from the date of receipt of the copy of the order. Yes, next.
Number 3, case part. We hear him? Yes, consumer.
Your Lordship, with these to hear this matter, Your Lordship. The previous occasion, the question was after the restoration.
So when an order in MA is staring at you, or how can the trial court can pass another order?
Yes, sir. Now in my amendment, there are two major conditions here. One, if you go with the relief sought by the plaintiff, Your Lordship, the very suit is not considered, Your Lordship, because he is seeking to settle a scheme for the administration of the trust, Your Lordship.
No, which is answered in the MA.
Yes, Your Lordship, but that what?
That you have to question that order in the MA now.
That is the issue, Your Lordship.
No, that you have to question that order. No, what happens is,
yes,
precisely, your application is filed under Order 7, Rule 11. Yes, that is already decided by the court in MA, though that particular that application in the form of Order 7, Rule 11, whether it is there or not, the appellate court has already decided that it is maintainable. Then when the trial court take a different view.
But Your Lordship, what does my submission is that, Your Lordship, whatever the opinion or whatever the observation has been made by the appellate court is binding upon the trial court, Your Lordship. My only humble submission is this honorable court will be pleased to produce the prayer, Your Lordship.
Sir, no. This court cannot find fault with the order passed by the trial court right now, because it has done it is perfectly legal and valid, because it cannot. So what is what is open to you is question that order if I passed in the MA.
Yes, that we have instructed the client to.
Will pass an order.
Yes, but my intelligence will be raised, Your Lordship.
That I'll record.
The very clear.
The agreed with orders passed in. Where is the order impugn?
Annexure.
Page number
58.
Agreed with orders passed in. I number 5, invoice number 155/2018, dated 1st July 2020. The defendant is before this court.
1 to 7.
Defendant 1 to 7 are before this court. The defendants of the suit is filed. Where is the plaintiff?
Annexure 8, page number 10. Suit is for declaration and proceedings.
Page number?
Page number 10, annexure 8. The prayer is forthcoming at page number 70, paragraph number 21. Suit for declaration and interpretation.
The suit is filed. Seeking declaration that the resolution dated 31/1/2016, 24/4/2016, and amendment of the trust dated 10/5/2016 are illegal, inoperative, void, and without jurisdiction. And also sought for an injunction restraining the defendants from causing interference, obstruction to the plaintiff's chairman, founder, trustee from exercising all the powers and performing duties as per rules and regulations of the plaintiff trust in any manner whatsoever. Earlier, even before the notices are issued to the defendants, when the plaint came to be rejected, the plaintiff had preferred MA number 11 of 2016. That came to be allowed by order dated 9th April 2018. The senior civil judge court, by order dated 9th April 2018, has observed that there is no feature to hold that the trust formulated through Memorandum of Trust Deed 12/5/2009 is public trust. The plaintiff has raised his legal character attaching to the private trust, which brought into light through Memorandum of Trust dated 12/5/2009. Even the provisions of Indian Trust Act and Karnataka Societies Registration Act, as noted in the trust deed, relied to govern those statutes, have also declared that the civil court had got jurisdiction, and through the jurisdiction of civil court, the dispute to be determined. Then immediate conclusion of the trial court holding that the said court has no jurisdiction to try the suit is not proper and not lawful, as contemplated under section 92 of CPC. The appellants therein has filed a miscellaneous appeal as against order passed by the court in the nature of final, and despite the court below has not returned the plaint to present the same before the competent jurisdictional court. However, the context of jurisdiction aspect apply with the provision under and it will match with the ingredients, and the present action of the appellant in the form is tenable in the eye of law. And accordingly allowed the application. Now the present application is filed in the similar lines. That the civil court has no jurisdiction to entertain the present suit in the present form, and it falls within the rigors of section 92 of the Code of Civil Procedure. Hence, the regular civil suit is not maintainable. The court gives a finding that already in miscellaneous appeal number 11 of 2016, the court has held that the suit do not come within the purview of section 92 of CPC, and also directed the judge to take cognizance of the suit and proceed with the adjudication of the same in accordance with law. Accordingly, the suit was made over to the court for adjudication. Defendants have not placed any document before the court to show that they have challenged the said order. By judging the factual matrix of the case with reference to the principles laid down in the decisions, declaration of individual or personal rights of the individual or personal rights of any other person or persons in whom they are interested, then the suit would be outside the scope of section 92. That the suit is quite maintainable before the civil court, as plaintiff has sought for declaration of his personal right in the office of trust and accordingly dismiss the petition. The petition, learned counsel appearing for the petitioner, defendant number 127, petitioners, defendant number 127 submits that the court has the suit in the present form is not maintainable and it has to be filed only under section 92 of the CPC. It is further submitted that the court has failed to consider the submissions made by the defendants and in a mechanical manner dismiss the petition. It is a contention of the learned counsel that the trust is a public trust and necessarily any dispute with regard to that falls within the ambit of section 92 of CPC, but not a regular suit is maintainable. All these aspects were not considered by the court. Next para. Having got the learned counsel for the petitioner, there is a material on record. Initially, on the maintainability of the suit before the trial, before the civil court, when the court has rejected the plaint and the same was questioned before the court, appellate court in MA number 11 of 2016, that came to be allowed on 9th April 2018, basing on the same. The trial court, basing on the same, the suit was entertained and the court suit was entertained and thereafter notice was issued to the defendants. So in the similar lines, now this application is filed. When the appellate court has already held that it is maintainable and basing on that the suit is entertained, now the court cannot pass any order contrary to the order view taken by the appellate court in MA number 11 of 2016, dated 9th April 2018. Court has also observed that the petitioners have not questioned the same. In that view of the matter, the appeal is, this petition is disposed of, giving liberty to the petitioners to assign the order dated so and so, passed in MA number so and so. Yes. Next.
Number 4, this is Somapu. This is Bhavaka.
Yes.
Response.
Petition is the
This is claim by mother against two major sons. Seeking
petition is the mother.
Versional. Right now she is the respondent. Then respondent is the mother.
So she filed the petition seeking maintenance against two sons.
Her sons.
What was granted?
10,000 is granted.
10,000, that is 5,000 each, to be payable by them.
Please.
Only in this case, the maintenance petition has been filed by only mother. Mother has filed the petition. The trial court has granted maintenance to daughter also. That is the.
That's the grievance.
Yes.
Let's see that. Let's see the order. How can it be?
My lord, as a mother, I am required to have maintenance from my major sons. They are enjoying the.
No, you mean to say she has a daughter, but she has not asked for from the
Yes.
daughter.
She is also having a daughter.
responsibility to pay the maintenance.
That's for her. That's not the ground. And generally, in a patriarchal society like ours, they're definitely like whatever the rights. It will be with the generally the mother will stay with the children with the sons, not the daughter.
My lord, here in this case, mother has filed a maintenance petition and then praying to grant maintenance to her. The trial court has granted maintenance to mother as well as her daughter also.
Let's see.
Her
Let us
daughter
see that.
That is the case.
No, both are the petitioners. Like, please come to that order, Srimati Mallamma. Then please come to the order, the operative portion of the order.
That is in the operative portion. Your Honor, please.
Monthly maintenance of 5,000 each to the petitioner. Each is, there are 2 children. So, 5,000 each, 5,000, 5,000, 10,000 to be paid to the mother. Where from you got to get that it is given to the daughter?
That is correct. I do agree. That is the case. One thing. And another, Your Honor, that here in this case, already in the properties, family properties, during the lifetime of father of the petitioners, that is a partition was taken place in the year 1992-93 itself. And during the partition, 3 acres 20 acres has been allotted to petitioner number 1, and 4 acres has been allotted to the petitioner number 2, and each one has been given one house. And another in one house, the father has taken one house and also 11 acres of land. 11 acres of land for including himself, his wife, that is the present respondent, and also daughters. So, including all, he has retained 11 acres of land in the family properties. So, since 1992-93.
1 minute. In the earlier matter, though notice is served to the respondents, there is no wakalat is filed on their behalf. No, R1 advocate. In this notice is served on R1, and when the matter came up on the last occasion, there was no representation, and the matter was heard and posted as part today. Today also there is no representation on behalf of R1. R2 notice is served, no wakalat is filed. Yes.
Please.
It should be in the order after the petitioner's contentions. Not order sheet. In order itself. Yes.
Here, in the year 1992-93.
No, those are all the.
You are not pleased to see here in the lower court, though these petitioners have been appeared to the council, they have not filed any objections and also they have not cross-examined the petitioner.
Yes.
Yes. And the trial court has passed the into an order that each of the petitioners shall give 5,000. So sufficient opportunity. Only one thing is that sufficient because in the year 19.
Why you have not appeared is the first question.
Because the elderly persons have settled the matter in the village itself.
To the court, when the matter is before the court, you have to appear.
Yes, that is before the elders, so the matter was settled, and the present respondent who is the petitioner therein, she has stated that she will withdraw that petition. So, believing on her words that it will be withdrawn, they are not one of the matter.
Those are not the grounds. No, court has spent enough time and passed orders. Now, why should we remand this matter to the court without it? And then on that, she has to pay the expenses and all to the advocate. No, she's already.
Already we have paid that 50,000.
Regular is paid.
50,000 rupees.
Except the amount of 50,000 that was
deposited
before this under court. Apart from that,
if you want the matter, if you want the matter to be remanded, whatever is the amount as of now, arrears at 10,000. If you are ready to pay, then we'll remand it. Please get instructions.
10,000. Because they are doing holy work. That is the only 3 acres of land. Or put it 90 that is landed properties also.
You should have brought it to the notice of the court.
It is my fault. That is
no, at least at 5,000 per month. How much it comes to? Because you are 2 people. 2,500, 2,500 it comes. You don't tell the court that it is also difficult. So at 5,000, right from the date of petition till now, what are the areas? If you are ready to pay that, then we will remand the matter. Please get instructions. Is this matter on Monday?
Tuesday.
On Tuesday under the same caption. Yes, next. And by the time the petitioner shall get instructions about the arrears, that's other matter, I think. Keep it in other matter. Yes, next.
Wife has filed the petition seeking transfer of the MC 107 of 23 from Gangavati to Surgupa district. Madam.
What is the distance?
Approximately 70 Madam, to and fro it will come 100 and above.
And when is the MC filed?
MC is 2024.
24.
Even she has
What are
filed-
your objections?
Madam, since there is no instruction from respondent side, madam.
You know, whether his instructions also we will transfer.
And in Surgupa she has filed for maintenance, on which she has appeared.
Any other petition is pending at the place where the wife is staying?
Yes, she has filed for the maintenance, my lord, in which she has appeared.
The present petition is filed. Seeking transfer of MC number 107 of 2023, pending on the file of the senior civil judge and JMFC Gangavati to the JMFC Sirigupa. The facts of the case are: the marriage between the parties solemnized on 5/6/2014 as per the Hindu rites and customs. It is the case of the wife that on 2011-2023 she has been thrown out of the matrimonial home along with the 3 daughters. And ever since she has been residing with the parents. On 6/12/2023, when the petitioner had approached the husband's parents to rejoin, they quarreled with her and assaulted the brother of the petitioner. Then the criminal case is registered, that is criminal case number 249 of 2023. Thereafter, it is MC of 2023, not 24. What has happened? What is the stage of it?
Stage it is for respondent,
We have filed a
petition filed objection, madam, for the main.
Then the husband had filed MC number 107 of 2023 under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. The wife had filed a criminal miscellaneous number 960 of 2023 on the file of the JMFC Sirigupa under section 125 CRPC seeking maintenance. In that, notice is ordered and the respondent is also appeared. Line counsel for the petitioner submits that the distance between both the places is 70 kilometers.
One way, both ways.
We look at one way. The is 70 kilometers, and it's very difficult for the wife to travel all the way. And further, she has to take care of 3 children, and there is no financial assistance from the husband. And the maintenance case is pending, and he is attending before the courts at Sirigupa. Next part. Let counsel appearing for the respondent husband submits that. In fact, she also appeared before the court at Gangavati. It is the enough number of public transportation is available, and in fact, the husband is ready to take her back. As such, he has filed the petition for restitution of conjugal rights. The wife, without a reasonable cause, staying away from the husband, and now she seeks a transfer of the case. In the facts and the circumstances, she is not entitled for transfer, and no grounds are made out. It's for having heard the counsels on either side. There is a material on record. It is undisputed fact that a maintenance case is pending on the file of the Sirigupa court, and husband had filed the MC on the file of the senior civil judge court, Gangavati. He has to come to Siriguppa for attending the maintenance case in that view of the matter. Further considering the fact that the wife had to take care of 3 children and the other financial aspects, inconvenience to her. Considering all that, this court deems it appropriate to pass the following order. So and so filing on the file of so and so is withdrawn and transferred to so and so, accordingly allowed.
Still number 6. Let this part come then.
For petition, wife petition, transfer of matrimonial case filed by the respondent, pending on the file of principal family.
Why is it posted for partner? He was not there yesterday.
Respondent had not appeared yesterday.
Yes.
We can transfer from Bangalore to Gokak.
Bangalore to
Gokak.
what is the distance?
528 kilometers.
When is this MC filed?
MC is filed on 5/6/2024.
Any matters pending at Gokak?
Gokak, there's a maintenance petition filed by the
Yes.
wife.
Please come. The present petition is filed seeking transfer of MC number 3353 of 2024, filed by the husband pending on the file of the 5th Additional Principal Family Judge Bangalore to the Principal Senior Civil Judge Court. What is it?
Gokak.
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 Gokak. Gokak. The facts of the case are that the marriage between the parties solemnized from 5/5/2020. And you have the differences between the parties. The husband had filed MC number 3353 of 2024 seeking divorce before the Principal Family Judge Bangalore. The wife had filed criminal miscellaneous number 807 of 2024 before the Principal Civil Judge and JMFC Gokak seeking maintenance of Rs 25,000 per month. It is stated that the distance between both the places is 524 kilometers, and it's very difficult for the wife to travel all the way from Gokak to Bangalore. And further, already a petition is pending before the court at Gokak where the husband has to attend. And so it is submitted that the matter may be transferred from Bangalore to Gokak. Next para. This matter came up on 7/11/2024. On that day, this court has heard the learned counsel with the petitioner in part. There was no representation on behalf of the respondent. For giving him an opportunity to appear and argue, this court the matter is adjourned to today. Today also there is no representation on behalf of the respondents. Hence, this court is proposing to pass orders on the merits of the matter. Next one. Next file line. Having heard the learned counsel, the petitioner peruse the entire material on record. That is, considering the distance between both the places, that is more than 500 kilometers, and the fact that already a criminal miscellaneous petition seeking maintenance is pending at Gokak, this court deems it appropriate to allow this petition and pass the following order. Accordingly, MC number so and so pending on the file of so and so is withdrawn and transferred to so and so. Accordingly, petition is allowed. The notice to respond in number 1. What is this? Which year is this? 2022. So what to do? Within a week's time, steps shall be taken, or else the appeal shall stand dismissed without further reference to the court. Next.
Still number 7. Still number 8.
8 steps for 3 times. Thereafter, I have served on advocate appearing
For the respondent. So RPFC, nothing is pending. Yes. File an application for substitute service. Then counsel the petition shall come up with an application for substitute service by 19th of November. By 19th of November, or else the appeal shall stand dismissed without the petition shall stand dismissed without reference to the court. Yes, next 9. Notice to R1, R1 and R2 returned as refused. Amounts to service of notice. List is matter for admission tomorrow on Monday. Yes. Not 1 week. List by 12th of November, the office objection shall be complied, or else the petition shall stand dismissed. You want to do it. The petitioner submits that during the course of the day he will comply with the office objections. Yes, next. No representation for dismissal on Monday. Yes, next. Same. No representation for dismissal on Monday. Yes.
My lord, my apologies, man.
Yes, which matter?
Serial number 14, my lord. 4 days time, my lord, I will comply with the office objections, my lord.
For complying with the office objections, the office objections shall be complied by 14th of November. Same default order. Next 15.
Please, my lord.
Office objection at serial number 5 is my lord. Respondents, my lord. Children are not made party, my lord. I have no objection to pay the materials in respect of children. I have only challenged in respect of wife, my lord. So I have made a wife as a.
Then you can write for this application. They are not necessary parties.
Yes,
you can write to file a memo to that effect.
Yes, my lord. As future, my lord.
Yes, next. No representation from dismissal on Tuesday. Yes. Same order. Same order. 19.
Petition has become infectious.
Then counts for the petition submits to the main MC itself is disposed of. MC or criminal misdemeanor?
Yeah, RPFC matter has been settled.
It submits that the matter itself has been settled between the parties and the petition has become infectious dismissed. Yes, next 20. No representation for dismissal on Tuesday. Yes.
My lord, serial number 21, my lord. I have given no objections, my lord. My name will be deleted. Myself, Abhilash Harman.
You should file a memo with all the details. Memo of
the other counsel's name is appearing, my lord.
Yes, given up. Yes, given up Wakalat, will come up with an appropriate petition, filing a memo of retirement. List this matter on 14th of November. Yes, next 22nd.
Lord, may I submit, my lord?
Office objection number 10, my lord. We have put a note, my lord, regarding the office objection number 10.
What about 9 and 14?
We will comply the 9 and 14.
What is 10?
Death extract of defendant number 2, 3, 6.
Death extract of defendant and to be furnished.
We have put a note, my lord.
Where is the note?
Page number 9. Okay.
Which one? Note 1 or note 2?
Note 1.
In the light of note number 1, the objection of the office with regard to the objection at serial number 10 is overruled, and the objections at 9 and 14
Objection number 9, my lord, we have by mistake made a party. Dependent number 2 made a party, my lord. We have told about this, my lord. Note number 1, we have told about this.
What you have told?
Dependent number 22 was also died.
That is with regard to serial number 9.
Oh.
Note 2 is serial number 9.
9 and 10.
With
Objection
regard
number
to
9
serial
and
number,
10.
with regard to the objections at serial number 9 and 10, there is a note 1 and note 2. In the light of note 1 and 2, the office objections at serial number 9 and 10 are overruled. 14.
We will
14. The petitioner shall comply with the objections by 13th of November. Yes. Or else the petition shall stand dismissed without further reference to the court. Yes, next.
Number 23. Yes, company.
I can do the informal during the course of the day.
Yes.
I repeat not this might be posted on 12th.
Yes. Land counsel for the petitioner submits that will comply with the office objections in the course of the day. List is matched on 12th. Yes.
Number 24.
Which time may be accommodated?
A week's time. Same default order. Yes, next.
Number 25.
Yes, 25. No representation. No representation for dismissal on Tuesday. Yes. 26.
Number 26.
No representation.
Number 26.
This also for dismissal on Tuesday.
Number 27. Shall we go on?
Same Tuesday for dismissal.
Number 28, number 29.
Same for dismissal. For dismissal on Tuesday. Yes, next. 30.
Number 30.
A week's time is granted. So default order. Next, please.
Number 31.
A week's time default order. Next, 32.
Number 32.
No representation. Tuesday dismissal. Yes. 1 minute, 1 minute. 30?
38.
It's only 32 that's called. Yes, 30. Yes, 33.
Husband petition. 4,000 is granted. Para 8, my lord, your lordship may. It is a reasonable lordship may dismiss.
Acceptance of memo, check filed by counsel for petition as per order. You deposited the amount.
Yes. In page 22, para 18.
Para?
18. 1A of the impugned order.
$4,000 is granted.
Yes.
You are for the husband.
Yes.
Please come. Agreed with the order passed in criminal miscellaneous number 171 of 2023 dated to 2nd February 2024. The husband is before this court. The case of the wife is that the wife had filed criminal miscellaneous seeking maintenance of an amount of rupees 30,000, litigation expenses of rupees 50,000. It is a case of the wife that she has been ill-treated by the husband, and the family members have abused and assaulted her, and out of the wedlock, she gave birth to one male child, and due to ill health, the said child died. It is a case that respondent is getting rupees 5 to 8 lakhs income from the land. he is running a chicken shop and is getting daily income of rupees 15,000 to 20,000. And she has no source of income and she's not in a position to maintain herself. The trial court has given a finding that the husband had neglected her. And when it comes to the quantum of maintenance, the court observes that the wife had claimed maintenance of an amount of rupees 30,000 per month, which is an exorbitant one. And it is prima facie found that cause of action would be served if the petition is granted reasonable maintenance by keeping in mind the inflation and high cost of living index. And in the process of doing complete justice between the parties, the court had granted an amount of rupees 4,000 per month. Aggrieved thereby, the husband is before this court. The learned counsel appearing for the husband submits that the amount that is granted by the court is on the higher side.
And also it is expert, and it is expert.
And it is an ex parte order, and without any basis, such an order is passed. He submits that the wife is not entitled for maintenance, as she neglected the husband. As such, the order impugned is liable to be set aside. Next paragraph. Learned counsel appearing for the respondent submits that the court had granted only an amount of rupees 4,000. Even that is also questioned by the husband. It is submitted that when he has received the notice from the court, intentionally he has avoided, and now he is coming up before this court with different stands, and the petition is liable to be the RPFC. The RPFC has to be dismissed as per. Having got the learned counsels on either side, there is a material of the court. The wife had claimed maintenance of an amount of rupees 30,000 per month, and litigation expenses of 50,000. Court had granted 4,000 as maintenance and 10,000 as litigation expenses. The ground that is raised by the husband is with regard to that it's an ex parte order. Why he has not appeared before the court when he received the notices? No positive explanation is coming forth. Even neither he has appeared before the court nor before this court he has filed his statement of assets and liabilities to show that he is not in a position to pay even an amount of rupees 4,000. In that view of the matter, this court finds no reasons to interfere. Accordingly, the petition is dismissed. What is this check? Why have you filed a check, not a DD?
DD it is DD. They say it is.
As per the order passed for this court, a DD is deposited before this court, and the respondent is at liberty to withdraw the amount. Yes. Next.
Number 34. Chandrasekhar.
Week's time, madam.
Yes, a week's time default. Next. Yes, 35.
Number 35. Silverty.
The petitioner allows a week's time.
Week's time default order. Yes, next.
Number 36.
Week's time.
Yes, a week's time default order. Yes, 37.
37. TN Brigade.
Week's time default order.
Number 38. Vivek
And it's some 13.
Huh?
30.
You will comply by then.
Yes.
Learned counsel for the petitioner submits that give him submits that he will comply it during the course of the day. This is marked on 13th. Yes.
Number 39. If you would be.
It's matter. As an objection to be complied. Within week's time, I will comply.
A week's time.
There is an interim order. The Honorable Court has granted me payments 4,000 instead of 7,000, which was in normally always by the High Court. And now, in the month of from June 2021 to September 2021, after the marriage, before filing of the case for maintenance, now the petitioner has already paid a sum of rupees 2 lakh to the account of the respondent. Now the trial court was asking for the modification of the interim order saying that whatever the amount which has been deposited to the account of the respondent after the marriage, it should be considered as an arrears which was not been paid earlier. not coming to produce some documents.
You have an interim order. What is the business of the trial court now in all this?
Now they are issuing the warrant for us to
Stay is granted.
for the payment of the arrears. Every week, my lords, we are running to the court to the recalling of the warrant, and he has made some of the loans for
No. When pursuant to the order dated so and so, when there is stay of all further proceedings, how can the court do anything?
They are seeking same clarification from the Honorable Court.
What clarification?
For that reason, my lords, I have stated, my lords, I have given one written submission, my lords, to the trial court, but they are not able to consider.
What they want? What clarification they want?
They say that whatever the amount which has been paid after the marriage, my lords, it needs to be adjusted in the arrears amount which has not been paid.
No, why should we clarify that?
For that reason, my lords, I have moved this matter as an emergency. Hence, my lords, in that interim order, a line may be added wherein
For maintenance of an amount of rupees 13,000 is granted.
7,000 has been granted.
7,000 is granted.
Please.
That is reduced to 4,000.
4,000.
On that condition, stay is granted.
Please, ma'am.
And you have been paying it as per the interim.
As per, please, ma'am.
So what else this court needs to clarify?
Once they say that arrears amount needs to be paid.
Which arrears, sir?
Earlier amount.
Then if the court, let the court pass some order, we will see.
They are,
How can the court insist when there is stay of further proceedings? Why should this court satisfy the trial court saying that no, this is not the order?
True.
Not necessary. Let the court order, let the court do something and you move the court. Then we will tell the court.
Please. Week's time will be like this.
A week's time for complying with the office objection.
Great.
Bill number 40, to go to the act of warrant.
I need a memo for production of additional documents. What has happened? Year 2000.
We are on furnishing of PFD.
I took up handsome from the council.
Do that. The petition is permitted to, without doing all that, will not do anything now.
What has happened on Monday is posted for others.
Then why are you not doing all this?
When the PF was
You do it, you do that, we'll take the smarter on Monday. We'll not do it. The petitioner shall comply, shall pay the process. If the process is paid, list this matter on Monday. And the petition is permitted to take hand summons on the counsel appearing for the respondent before the trial court. Yes, next.
Bill number 41.
Let counsel submits that he'll comply the objections by Tuesday. If objections are complied, list this matter on Wednesday. Yes.
Bill number 42. Election company.
No, I may be permitted to withdraw the petition orders.
Take that. A memo is filed seeking to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes, next.
Bill number 43. Bill number 44. Suraj Kumudho.
No representation. List this matter for dismissal on Wednesday.
30. Bill number 41. Foundation ceremony.
But 6 weeks time, I will take the instruction and make the submission.
Finally, a week's time is granted. This is matter on 19th of November.
Please.
Yes.
Bill number 46.
No representation for dismissal on Wednesday.
30.
Yes.
Here the petition minutes, needful is done, minutes. I complied to office objection. Minutes, I will be permitted to file a memo. This CRP is filed challenging the order passed in 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 4 minutes. However, the suit itself is dismissed for non-prosecution. And filing a memo to that effect. Liberty may be reserved to revive the same minutes if
Take that memo.
That's one more submission. Yesterday I had represented the matter, however, my absence is shown minutes in this matter.
That also I'll record in this.
Great.
And then counsel, a memo is filed stating that the suit, OS number 34 of 2020 is dismissed for non-prosecution. And this petition arises out of an idea filed by the an idea filed by the defendant, that is IA number 4 under Order 7, Rule 11. He submits that the petition may be dismissed with the liberty to the petitioner defendant to renew this application if the suit is restored. Land counsel submits though she has represented the matter, but it's shown that the proceeding shows that there was no representation. Yes, accordingly the petition is dismissed, giving liberty to the petitioner to renew the application if the suit is restored. Yes, next.
Number 48, RH which is Chikmagalur.
You have it on.
Why?
You have to get some instruction.
Finally, on Wednesday, no further time.
30. Number 49, which is petition.
No representation for dismissal on Wednesday. It is already in dismissal. Give that. Right from October 3, 2023, this matter underwent several adjournments for paying the process. On 7/11/2024, when the matter is called, there is no representation on behalf of the petitioner, and this matter was directed to be listed under the caption for dismissal. Even today also, there is no representation. It appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes, next one.
Number 50, Joshi. Number 50, Ashwati Joshi, P. Nagarajappa.
Right from 22/9/2023, the petition is not complying with the office objections. On 6/2/24 also, there is no representation. On 7/11/2024, when the matter is called as there is no representation, the matter was directed to be listed under the caption for dismissal. Same. Today also there is no representation. It appears that the petition is not interested to pursue the matter. Yes.
Number 51, Mantesha Sirema.
This needful has been done well.
Land counsel for the petitioner submits that the needful is done. This after service of notice. He reads from the caption for dismissal.
Please.
Next 52.
Number 52, Sanjay Vadekar. Satyanarayan, small right.
Right from 6/3/2024. This matter underwent several adjournments for paying the process. And finally, on 12/8/2024, a week's time is granted for doing the needful. And when the matter came up on 7/11/2024, again there is no representation on behalf of the petitioner. As the matter is directed to be listed today under the caption for dismissal. Today also there is no representation. Accordingly, dismissed for non-prosecution. Yes, next.
Number 53, Sage Bhai.
Sections. On 7/11/2024, when the matter came up, as there was no representation, the matter was directed to be listed today under the caption for dismissal. Today also there is no representation. Accordingly, dismissal non-prosecution. Yes.
Still number 54, contentious element.
Weeks time is given, so I'll complete office objection.
Delete from the caption for dismissal. A week's time is granted for complying with the office objections with the default order.
Please.
Yes, please.
Admission notice is number 55. हमने पढ़ा है
Here for appellant in the connected matter for the petition, I am filing memo for withdrawal. Matter has been settled.
This is also same.
Take that also. Yes. Both the wife and husband in both the petitions have filed a memo to withdraw the petition stating that the parties have amicably settled the matter and they are not interested to pursue the matter. Accordingly, dismissed as withdrawn. Yes, next.
Still number 56, 57, 58, address still number 59. Taken to indicate.
Council on record is held up in court
Passover?
number 9. No, ma'am. Mechanically have in mind.
Why? End up in 9, forever he will be in court number 9.
Afternoon, due to some personal work he is doing.
So no mood to work on Friday.
Monday.
List this matter on Wednesday at the request of non-counsel petition.
Please.
Still number 60. Second part. Then Monday. Second part.
There is a counsel for the petitioner.
Still number 60.
Then counsel for the respondent is present. No representation on behalf of the counsel for the petitioner. List this matter for dismissal on Wednesday. Yes.
Still number 61. Still number 62. There is agreement. So then we apple.
There is a counsel for the petitioner. Same order on Wednesday for dismissal. ज़्यादा हो गए तो फिर 12th को 12th 14th को 14 2-3 matters 14th all the even before matters also on 14th. Yes.
16.
This is too many matters on 13th. Let it be on 14th. Yes.
Still number 16. I will just pata.
Something somebody has mentioned in the morning. Somebody has mentioned in the morning. 63 also on 14th, not dismissal. 14th. At the request of your counsel, this is matter on 14th. Yes.
62.
Which one?
64.
Yes, 64.
I am for the respondent.
Appearing on behalf of the petitioner.
Yes.
My lords, this petition is filed challenging the order in criminal miscellaneous 264 part 2.
You are for the wife or husband?
Husband, my lord.
How much is the money amount granted?
20,000.
What is your salary?
I am an agriculturist, my lord. I have only 4 acres land in my name, and my wife is actually my sister's daughter, and they have also filed a partition suit against my family. And I have 2 children in my custody, and she has 1. And I am paying for all the fees and everything else. And I'm also a cardiac patient. So this is.
Please come to the order. Come to the order.
My lords, the order here. So basically, the wife sought for.
Come to the reasoning part.
Reasoning.
Para number 8. Please
Yes.
start reading.
Yes, my lord. My lord, it's an admitted fact that the.
No, might be an admitted fact. Let the court understand the facts. Start reading from point number 8.
Yeah, okay. The petitioner, in order to prove her case, got herself examined as PW1 and got marked 12 documents as Exhibit P1 to P12, and respondent himself examined as RW1 and got marked documents R1 to RE. It is to be noted that admittedly the marriage of the petitioner and the respondent had taken place way back in the month of April 1999, and that they have 3 children out of wedlock. It is a specific allegation of the petitioner to the effect that right from the date of the marriage, because of the pre-existing relationship between the parties, she went to her matrimonial home. Though initially she was treated very well in her matrimonial home, but later on, her father-in-law, being the brother of her mother, began to harass and pressurize her to bring more dowry from her parental home, which ultimately culminated into asking the petitioner not to seek a share in the ancestral property, wherein the petitioner's mother and the respondent's father, being brother and sister, having the share in the joint family property, which has in turn affected the colored relationship between the petitioner and the respondent. My lords, if you go through this point, there is no dowry case nor any 498A filed by.
Please complete reading.
It is the specific allegation of the petitioner that though her husband, being financially very well, having agricultural lands at Aravatagi and Margankopa village, as well as having RCC building in Belgavi, having other source of income, has failed to neglect her and her minor daughter. It is to be noted that, and it should not be lost sight of the fact that the petitioner has fairly and squarely admitted that she, being working in a private school, but her income of 12,000 rupees per month is not at all sufficient for their daily living, wherein under she is residing at a rental accommodation and paying 6,500 rupees per month, and the remaining salary is not at all sufficient both for her daily subsistence as well as daughter's educational expenses, which admitted that petitioner number 2 is a school-going child, and it is also to be noted that the petitioner has produced the school fee receipt, Exhibit P7, which shows that the minor petitioner number 2 is studying in 10th standard at Gnanadeep Education Trust and GG Chitnis English Medium High School, having paid rupees 8,700 of May 2022 and rupees 2,500 each as monthly fees in the month of September 2022 and January 2023. Thereby, coupled with the educational expenses, will not at all be sufficient for a comfortable living of the petitioners. Also, it is to be noted that the petitioners have produced document to show that she is suffering from ill health, and at the same time, it should not be lost sight of the fact that the father-in-law of the petitioner, vide Exhibit P4 and P12, has assaulted the petitioner admittedly at Halyar bus stand, which clearly discloses the deteriorated relationship between the petitioner's family and the respondent's family. At the same time, the respondent in his defense has contended that he is a poor agriculturist, not at all having any independent source of income, and therefore that the 4 acres of agricultural land and not at all growing any commercial crops, and wherein his wife is having a definite source of income of rupees 12,000 rupees as a school teacher. Therefore,
please come to this page number 19 and read that Kannada portion and tell the court what it is.
Yes, my lords. ತಾವು ಅವರಿಗೆ ಯಾವುದೇ ಆರ್ಥಿಕ ಸಹಾಯ ಮಾಡುತ್ತಿರಲಿಲ್ಲ, ಅನಿವಾರ್ಯವಾಗಿ ಅವರು ಕೆಲಸಕ್ಕೆ ಸೇರಿದರು ಎಂದರೆ ಇಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿ 4 ಚಕ್ರದ ವಾಹನ ಇದೆ ಎಂದರೆ ಇದೆ ಎಂದು ನುಡಿದು ನಮ್ಮ ಅಣ್ಣನವರು ಲೋನ್ ಮಾಡಿ ಪಡೆದಿದ್ದಾರೆ ಎನ್ನುತ್ತಾರೆ. So here the translation is, when the petitioner in the present case was asked if he has forced the respondent to work, he is denied it, and he was asked that he has a 4-wheeler in his name, to which he has replied that the 4-wheeler was actually brought by his brother. Nipi 9 ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿ.
Yes, I have seen it. Yeah. What do you say?
Madam, I'm requesting short accommodation till Monday night.
And what were you doing all through?
Morning, I had requested my lord as we started.
Why? You should have asked when you started document.
Sorry, ma'am.
Heard the counsel for the petition in part at the request of learned counsel for the respondent. List this matter as part heard on Thursday.
Number 65. What is that? Election campaign. What is that? 65.
Yes.
I request to next week.
Why next week? This is matter on 20th of November at the request of non-counsel the petitioner. Next.
Sorry.
Next.
The both minutes we are trying to settle the matter. Morning we have may I seek minutes and short accommodation to see the settlement.
This is matter on 2nd of December.
Please, please.
It is submitted that there is a likelihood of settlement.
Please.
Yes. Next. Inter-alia granted is extended till then. Yes. Next.
Number 67 and number 68. Scarvio.
Take the mic. Court should hear you also. Yes.
Respondent has filed the criminal misdemeanor 79.
How much is granted?
10,000.
Huh?
10,000.
What is your income?
20,000. And net salary is 20,270.
The counsel of the petitioner submits that when the income itself is 20,000, court had granted 10,000 to the wife, and it is difficult for the husband to pay the said amount. Considering the submission, they shall stay call for the proceedings on the condition that the petitioner shall pay an amount of rupees 6,000 by 5th of every succeeding month.
4,000.
Huh?
4,000.
The 6,000 by 5th of every succeeding month, and shall deposit the arrears at 6,000 within a period of 8 weeks from the date of receipt of the copy of the order, either that amount or this is not paid, the petition shall dance. The stay granted by this court stands vacated. Issue notice to the respondent.
One submission. He is having a loan of 5 lakhs because of her grandma, because of his grandma.
Make it 5,000, not 4,000. Yes, next.
Number 69. RHMP. Sanjay Sanjay.
Yes.
Husband. The trial court has passed an order and fixed the amount of maintenance at the rate of 8,000 rupees to the wife and 2,000 each to the children. In all 14,000. The present petitioner is a authority driver.
In all 4,000?
14,000.
14. It is 4,000 each.
8,000 to the wife, madam, and 2,000 each to the children.
3 children?
Yes, ma'am. I have filed 14,000.
My petition is there, madam. Wife and children have filed.
Take that, post along with that on Thursday, 14th.
Please, records
Inter-alia granted is extended in them.
Records may require, bulk of records were produced to show his income.
We'll see on that if required.
And my lord, recently they have deposited, there was an order of interim order.
Deposited?
4 weeks.
There is a delay in depositing the amount, but as of this time, the entire amount is cleared out. An amount of 4,44,000 is deposited.
That they can withdraw.
Please.
The amount deposited by the.
Some amount may can be deposited in the name of the minor children for benefit, for their benefit, for their education.
We'll see, then it's coming up on Thursday.
Please.
Yes, next.
Number 70. Jason. Subhash.
No representation for the petitioner, counsel, the respondent is present. This is matter for dismissal on 14th. Yes. Next.
Number 72.
Dismissal on 19th, counsel, the respondent is present. No representation for the petitioner. Next.
Number 73 and number 74. RHMD. Disseminate.
The 10,000 is fixed as maintenance to the wife and 7,000 to the child.
17.
Yes, sir. The present petitioner is working as an agriculturist. He has only 1 acre of land for his earning his livelihood.
You didn't contest the matter?
I have contested the matter, but the trial court, by referring to the record of rights which have been produced, has jumped to a conclusion stating that it earns some income.
How much is the land?
It is 1 acre only.
In 1 acre, according to the court, how much amount will be? Oh,
At the most, 50 to 60,000 per year, that will be an earnings from that land.
so now
Since these areas-
how much is granted? 18,000. How much is granted? 18,000.
But without there being any quantum has not been fixed by the trial court. And without fixing the quantum of income of the husband, the trial court has fixed some amount on guesswork. Absolutely, there is no findings given by the trial court to fix such amount.
On the last occasion, Twin Motor has been granted to pay, to deposit the amount on.
Not deposited?
He has not deposited. He has not.
Why?
Since it is very difficult for him.
How much is the amount granted?
14,000 was granted.
No.
50% was to be deposited. In my submission, the petitioner is very much ready and he is intending to go for settlement and he is ready to give the land to his wife and child, but they are not coming forward.
Both the parties are directed to appear for the mediation before the mediation center on 20th of November.
Please.
Next.
Connected petition, the connected petition filed by the 100,046 of 24.
You are the petitioner.
I am the petitioner. Is the husband, my lord, challenging the maintenance awarded by the.
What is this non-filing of acknowledgement for having paid costs of 5,000 per
That
month?
is not cost, my lord, that is maintenance, my lord. Maintenance, my lord, I have paid maintenance. I am paying the maintenance regularly. My lord, during.
Correct.
There is an arrears of 80,000 rupees. Last two occasions you have not turned up. Last occasion
Order
has
granted by this honorable court has been complied. And also they have withdrawn the, my lord, 75,000 before this honorable court. And my lord, this has been.
What is the order? In 75.1.
On 3/4/2024, my lord, this honorable court granted the interim
Family
order.
good. Subject to the petitioner depositing 75,000 within a period of 1 week.
I have deposited and also withdrawn.
You have withdrawn. Oh.
And thereafter, my lord, every month, my lord, 5,000 to be, my lord, deposited.
Paid. That you have not paid.
No, my lord, I have paid. During that intervention period, my lord, matter has been referred to the mediation. My lord, thereafter, my lord, I taken back my wife for a period of 1 month. My lord, they have not, my lord, adjusted to each other.
So that 1 month you have not paid.
1 month I have not paid, my lord.
Remaining you have paid.
Remaining I have paid, my lord.
Is it?
Balance is there. Only, he has paid only
You know,
70.
this order is on 3/4/2024.
Yes.
So how many months till now? It is 6 months.
There was a 1
That is
lakh.
50,000.
1 lakh. So earlier to that, there was.
No, that we are not concerned. The stay is granted on particular thing that is compliant.
With regards to same, I do not find any difficulty for that.
So now you have to argue, both of you have to
Yes,
argue.
yes, that is the.
Argue.
My lord, the petition is, my lord, 100,046 by
Do that. 100,046.
of 24 is filed by the husband. My lord, granting maintenance of rupees, my lord, 10,000 to the wife. My lord, he has a diploma holder and drawing, my lord, 50,000 salary. And also, my lord, the respondent is a wife. My lord, she is a BSc graduate. And she is also, my lord, the teacher, drawing 25,000 salary. As per, my lord, evidence given by the PW3, who is the one of the relative of the, my lord, respondent. My lord, in para number 15, my lord, page number 19 may kindly be perused. May I read, my lord? That for the reasons best known to the petitioner, she adduced no documentary evidence to prove that petitioner does not have immovable house properties in Bengaluru city besides having agricultural land of 3 acres in his native place. That the said immovable properties fetch income of rupees 1,30,000 per month to the respondent. In the absence of material evidence in this behalf, the assertion of the petitioner in this behalf cannot be accepted. Therefore, by taking established.
Where is that evidence with regard to her income?
My lord, PW3 is, my lord, the evidence. Adduced, my lord, these are themselves.
From the order.
Order and bandila. Order and bandila.
In the order, it is not.
It is not, my lord,
mentioned. Where is that? Evidence is in Kannada or in English?
Kannada.
Read. What is that particular part?
Last, my lord, para. Arjidar, that is, my lord, ಖಾಸಗಿ ವಿದ್ಯಾಸಂಸ್ಥೆಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಆಕೆಯು ಮಾಸಿಕ ರೂಪಾಯಿ 25,000 ಗಳಿಸುತ್ತಿದ್ದು, ನಾನು ಅವರ ಸಂಬಂಧಿಯಾಗಿದ್ದರಿಂದ ಅಸತ್ಯ ನುಡಿಯುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅರ್ಜಿದಾರರು ಬಳ್ಳಾರಿಯಲ್ಲಿ ನೆಲೆಸದೆ ಗುಂತ್ಕಲ್ದಲ್ಲಿ ನೆಲೆಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. My lord, adding to this one, my lord, immediately, my lord, see, after this is a COVID marriage, my lord. During the COVID, marriage has been taken place. They are the relatives. My lord, she left the company of the petitioner within a period of 6 months, and they are.
We are not on all that point. We are on the point of her income. So what he read?
He said that, my lord, I was working as a teacher. One of the relatives has given an evidence before the court saying that they are.
Whose relative?
Her relative, he says. There is no evidence.
No, he is examined on your behalf or on her behalf?
He has examined on her behalf.
On his behalf.
On his behalf. The court has said no document has been produced. Therefore, 10,000 is the reasonable amount that has been granted.
Now, without there being a contra evidence with regard to the income, 10,000 is a reasonable amount. If you could place anything before the court showing that she is working and she is earning, then we will consider.
My lord, she is also admitted that she is a BSc graduate. My lord, she herself has admitted in the evidence.
Maybe, but she is earning or not earning? That's the question.
Earning and towering my lord, she herself has admitted that, my lord, she is a BSc graduate and also doing teacher work, my lord.
Working teacher work?
How?
Where?
My lord, in PW, my lord. PW1, my lord, she has admitted in the evidence. May I read? My lord, ನಾನು BSc ಪದವೀಧರೆ. ನಾನು ಈ ಮೊದಲು ಶಿಕ್ಷಕಿಯಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಈ ಮೊದಲು.
Means?
Earlier.
Then why are you not working now?
There is no income, but there is no.
Why? Why are you not working?
No, he said that their assertion, I am teacher.
It is not assertion.
It is admitted by herself.
He is saying that.
Not
he is saying that.
He show it to him. What is that information?
ಒಂದು BSc ಪದವೀಧರೆ. ನಾನು ಈ ಮೊದಲು ಶಿಕ್ಷಕಿಯಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನಾನು ಈಗಲೂ ಸಹ ಶಿಕ್ಷಕಿಯಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಇದ್ದು ನನ್ನ ತಾಯಿ
ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ ಸರಿಯಲ್ಲ means
not correct.
Not true. It is not true.
Why are you reading like that?
No, my lord. See, my lord, initially
probably she might have said that the whatever you have suggested that she is working and she repeated it and said it is not correct.
Correct. That's
my lord. Initially, my lord, she has admitted saying that, my lord, she is working as a teacher. Subsequently, my lord, she has, my lord, denied me, my lord, that putting the question.
That question she repeated and she said no. How can there be like that? It will be the answer cannot be like that. When you put a question to her that you are working as a teacher, I am working as a teacher is not correct.
That is suggestion.
ನಾ ಈ ಮೊದಲು ಶಿಕ್ಷೆಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. That has been admitted. Earlier to, my lord, this petition, my lord, she is working as a teacher and also says a BSc graduate.
You can place any material before the court saying that she is working, we'll consider. Otherwise, no. If you want time, I will grant.
I will, my lord, some.
But as it is, if there is nothing, we'll confirm the order.
One question. What is further development that has taken place? He has filed a constitutional right before the Bangalore court, family court in Bangalore. This honorable court has suggested me to let them reconcile and let them go on. Therefore, matter was given to mediation report. Thereafter, 1 month time was given. If they are ready and they are happy, we'll close the matter. 1 month he has taken away from this court to the Bangalore. He has taken a rented house. The family members, father and mother, also staying in Bangalore. But he has not provided the food also. He is bringing I have filed a detailed
They will not going to all the
Ah,
time.
after-
Then counsel, the petitioner submits that. He'll place the material before the court to show that the wife is early. This matter on 26th of November. No further time will be granted.
Please.
Serial number 70. There are so many matters on 13th. That's why it's put as a 22nd. Okay, 70, 22nd. Yes. Next.
Serial number 76.
Where is the counsel for the petitioner? No representation for the respondent. No petitioner. There is a counsel for the respondent is present. This is matter on 20th for dismissal. Law for the petitioner. 76. Yes. Next matter.
First matter is by wife, and second is by the husband.
You appear for wife.
Yes.
How much is the amount granted?
35,000.
Still you are not satisfied.
No, wife 2 children.
What is the income of
My
the
order
husband?
is, that order is, there is a mistake, that maintenance is granted from the date of order.
You should have read from the date of petition. That is one.
One.
And what is the income of the husband?
My lord, he is a computer engineer. As my lord, he has, my lord, in the his assets, he has stated he is paying 1,18,000 installment to the bank. He is paying installment of rupees 1,20,000.
And what is his income?
Income is nearly more than 2 lakhs. Now he is working in Dubai.
Yes.
But I have submitted my declaration as assistant liability engineer. Earlier he was working as a computer engineer. He is PUC second year completed. He is not a graduate student. Whereas the wife is BA graduate. And apart from that, he was regularly paying an amount of 20,000 for maintenance of wife and child money. And in lieu of the order passed by this honorable court, he is regularly depositing an amount of 22,000. That is as per the order of this honorable court. And now he is ready for settlement. Since at the instance of his wife, he has purchased an agriculture land that is worth about 80 lakhs, and it was purchased in the name of his wife. And thereafter he has purchased that is NA site in her name also. Both are worth more than 1.25 crores. And now he is ready for settlement, but they are not really coming forward for
Yes,
settlement.
Mr. Counsel.
Please, ma'am.
Settlement.
The terms of settlement is not known.
Go appear before the mediation and see what happens.
No, he is in Dubai.
Let him come on someday.
He has to take that.
No, he will appeal to VC and I will make all of it before the mediation.
Let him appear.
Please, ma'am.
It is submitted that the husband is in Dubai and there is a scope for settlement. Considering the same, the wife shall appear before the mediation center on 26th November. The husband is permitted to appear through VC.
And it will be the interim order will be taken.
Interim order earlier granted is extended.
My lord, the amount in deposit which has
They will
been committed.
The wife is permitted to withdraw the amount deposited by the husband.
Please.
There is I am told, my lord, there is arrears of 3 months, arrears of.
Up to date here.
Serial number 79 and serial number 80. Here, this was the party person. SP.
Yes.
My lord, I filed this petition, my lord, to transfer the OS 195, that is money supplement. Money from Sirsi court to Colgate court of fair trial. 2014 my lord, ಇಲ್ಲಿವರೆಗೂ fair trial ಆಗ್ತಾ ಇಲ್ಲ ಬನ್ನಿ. ನನಗೆ
We'll pose this before the other bench. You can argue in Kannada. The party in person is not conversant with English. Is this matter before the other court
May I request, my
after
lord?
obtaining necessary permission?
May I request
He has supplied only the petition copy. There are
Supply him the entire papers.
entire paper.
The party in person shall serve the counsel for the petitioner the entire papers.
Grateful.
Yes.
Grateful.
Number 81.
No representation for dismissal on 20th.
Number 82. Amish Hajira.
Same order. Who asked for password? Asked whom? No, where is he? When did he ask? Huh? Huh? So he has to come now. Yes. For dismissal on 19th of November. Yes, next. 19th.
Number 83. Sukumar is forward.
Yes.
To be a petitioner. The husband's petition. Court below has granted that maintenance of 10,000.
10,000.
10,000. Yes, the ground on which the petitioner is before my lord's listeners, he is having 2 children who are staying with the petitioner husband. They have to take care of those 2 children. And admittedly, the petitioner is working as a cashier in a bar. He is not having a fixed income. The court below has granted us 10,000 rupees.
5,000.
Please.
Then calls for the petitioner submits that the income of the petitioner is 10,000 and the, what is your income?
I had tendered evidence to the effect that I have an income of 10,000 rupees.
Is having income of 10,000. The court had granted 10,000 as maintenance. It is submitted that the 2 children are staying with him. Considering the same, they shall be stay of all further proceedings on pursuant to the order dated so and so on the condition that he shall deposit 5,000 by 5th of every succeeding month and the arrears at 5,000 within a period of 8 weeks. Default order.
But I am having instruction that means there is no arrears. He has cleared all the arrears.
If any arrears.
Great.
Yes. Next.
Number 84.
Wife's petition, my lord, seeking a transfer of matrimonial case filed by the respondent from Bijapur to Bagalkot, my lord.
Bijapur to
Bagalkot.
What's the distance?
90 kilometers, my lord. MC has been filed in year 2020.
The calls for the petitioner submits that the distance between both the places is about 90 kilometers and it's very difficult for the wife to travel. Considering the same, they shall be stay of all further proceedings in so and so to the next date of hearing. And the petition is permitted to take out notice on the hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 26th of November. List this matter on 29th.
Number 85. Sadiq Kurwala.
Yes. No. No representation for the petitioner for dismissal on 27th November. Yes. Yes.
Number 86.
Matter was posted day before yesterday, my lord. Since I have also filed a criminal miscellaneous before the Mudhol court and even before these proceedings I have been granted maintenance and litigation expense of 5,000. There was some, your lordships also found that I have capability to earn. Therefore, I had requested the court, my lords.
No, I remember.
Yes, ma'am.
That day I wanted you to get instructions.
Yes, it is present, my lords.
No, tell her.
Yes, I have instructed her, my lords, that all claims will be kept open in the criminal miscellaneous proceedings to be adjudicated. This will not press.
You are not pressing.
Will not press. One request, my lords, is from the client's end is arrears still today are not paid. Arrears of what is awarded here is not paid.
No, when the court decides something, it will have an impact on the arrears also. Please come.
Or, my lords, even in terms of Rajneesh or Sneha, where in overlapping jurisdictions, my lords, it is kept open to be adjudicated even in the subsequent proceedings.
No, it is like this. I can understand it is under the Domestic Violence Act. Whatever that is the relief you get, it is in addition to that. Now, the MC is pending. You have filed an IA. How can you file a petition of 120 CRPC?
Understand.
That you cannot. For example, now the matrimonial disputes are resolved, and then you are filing an 125 CRPC. One can understand that, but not at this stage. You have a remedy. No, what will happen is neither you are here nor there.
Yes, that is the
But
reason
anyhow,
why.
let us settle that. The present writ petition is filed, agreed by the orders passed in where is the improved order?
It's, page 35. It's actually.
Agreed with the orders passed in IA number 4 in MC number 128 of 2022, where the court had granted maintenance of an amount of rupees 5,000 per month. When the matter came up for hearing, learned counsel for the respondent, basing on the instructions of the client who is present in the court, submits that she is not interested to press for this, and already she has filed another application and she will be prosecuting the same. In that view of the matter, the writ petition is allowed by setting aside the order dated so and so, passed in so and so.
All contentions kindly.
All the contentions are left open to the parties.
Please,
Yes, sir. Huh? Party का signature है.
My lord, I am for petitioner, my lord. Kindly weeks of time, my lord. I have already informed other side, my lord.
List this matter on
Kindly extend
29th,
interim.
28th of November at the request of front counsel for the petitioner.
Kindly extend interim order.
Interim order always granted is extended. Next. Next. For the 28th, they said. Yes.
Celebrating is fine very much.
Obtain permission of the last number. Make a mistake.
No, list is at there.
Please,
List is going on. 88. So, no representation on behalf of either side. This is matter on 26 for dismissal. 89. Who is he?
SP Sheikh.
You know, petition is not there. Counsel for the petition is not there. Counsel for the respondent is present online for dismissal on so and so. Yes, 89.
Number 89. Isn't there part
I am partner.
Yes.
The respondent wife and two children are filed petition.
Huh?
Respondent wife and two children.
You are for the wife.
I am for the husband.
How much is the maintenance sought?
Total amount of 12,000 has been awarded.
12,000.
12,000.
8,000
to the
wife. 4
and
to the children. What is your income?
But if I for the salary settlement, gross income was 30,000 at that time. And after deduction, come to 22,000.
Even in that way also, what is granted is reasonable only.
What happened? Due to continuous harassment and various filing of criminal cases in law, the petitioner of the hearing he has also filed suit for between the resolution of marriage, and that came to be declared in law.
That came to be decreed.
Declared in law.
Permanent alimony is not granted.
Permanent alimony is not granted, but 1 lakh has been not awarded as in not the litigation cost to the wife, not that has been awarded.
Then what happened?
Not that appeal is against that, not the appeal is filed by not the wife, and that is a pending hearing before the arrangement of the law. The petitioner is not the husband is not he is not the Hindu. The wife is not he is a Muslim or Muslim. They both not the love marriage have taken place and they not the.
No, the matrimonial matter itself is disposed of under 125 CRPC.
125 award. It is maintenance has been awarded. Maintenance has been awarded to the
during the pendency of it.
During the pendency divorce petition. The divorce petition now it is pending before this honorable court in MFA number 101-779 of 2021.
Please the matter on 17th of December.
And the also filed criminal cases serious and not 7 and 498 law. That case has ended in acquittal. And because of filing of not various complaints and criminal cases, I have been
because MFA is pending, let's not pass any order in this.
Terminated from the service law. And now they are after inquiry conducted after preparing appeal, again I have been reinstated.
Therefore, now rejoining is not possible because of all this,
That's why let MFM be decided, whatever it is. Yes, next.
So number 9, the announcement. Question.
Tenants. 10,000 is awarded.
Where is the concept for the response?
Question. Correspondent. Still number 9.
Land counsel for the petition is present, heard in part. No representation for the respondent. This is matter on 14th as part heard. Yes. Next.
Still number 91. Still number 90. Martin Raj.
What's the petition law? So trial court has not the.
Ready?
And for the respondent,
You are ready?
please.
But the wife has filed one of the petition before the family court law seeking maintenance of rupees 20,000 law.
Court has granted how much?
But the petition came to decision law.
On the ground?
On the ground, on two grounds, one is that the
Page, para number 17, your lordship, internal page number 15 of the trial court order.
one first ground is that the wife has failed to prove that the husband has shown any type of harassment or cruelty or the failed in.
These are all serial type of orders in everything.
Your lordship, there is a two grounds the trial court.
That is first ground. With respect to that, I have filed two cases, one under domestic violence act and one under 498 case is still pending. In domestic violence act, it is fraud, and the respondent husband has been directed to pay the monthly maintenance of 5,000.
Let's read the order.
Please. The reasons of on the page number 25, paragraph.
Please read from
17 is the operative portion.
huh?
17, page, para number 17 is the operative portion.
Not operative portion.
Yes. Why the trial court has dismissed to grant the maintenance?
Second ground is that
Read from 17.
please. Paragraph. The material placed before this court to indicate that the petitioner does have two other siblings to her parents, that her father is no more, as the extra prior to the unrestricted marriage of the party hereto. That one of the sisters, that the elder sister of this petitioner, works as an officer at the office of IG in Bengaluru city and has stayed in Bengaluru. That the younger sister has been given in marriage and she resides along with her husband to her matrimonial home. That as of now, the petitioner, her mother and her maternal aunt do reside at their own premise in Mocha. The petitioner initiated proceedings before the woman police of Ballari and criminal cases also pending against the respondent and others at the extent of petitioner before the court of law and principle. The materials available to also narrate that the petitioner led magistrate life with the respondent along with her parents in law just for 15 days. The acknowledgement issued by the woman police executive preferred has mentioned that petitioner here has approached the woman police station of Ballari on 2/11/2021 at about 10 p.m.
Come to paragraph 22.
Please. Undisputedly, I don't know the date of petition, the parties hereto are not living together. Thus, the materials available to this court to establish that marriage of the parties hereto was performed at Ballari, that subsequent to marriage, the parties hereto commenced their marital life along with the parents of the respondent at Gundikal only for 2 days. Thereafter, separate house was made wherein they lived with cordial relationship only for 2 days. Thereafter, the petitioner left for Mocha with allegation that the respondent used to return home during the late hours by consuming alcohol, but the said assertion has not.
This has to go. These kind of inquiry can't be done under 125 CRPC. We'll set aside this order. We'll remand the matter to the court below to consider it on the quantum of maintenance.
With respect of maintenance, your lordship, para number 23. Since he is getting 5,000 of a
No,
maintenance.
but that's not the ground. It is
Please.
whatever it is on the domestic violence is in addition to the other issues.
Please, yeah.
The agreed with the orders passed in criminal miscellaneous number 233 of 2021, dated 20th of July 2023. The wife is before this court. The wife had filed a petition seeking maintenance of an amount of rupees 20,000 per month from the husband, and the same came to be dismissed. The reasons for the trial court to dismiss this petition is that the wife had failed to prove that she has sufficient excuse so as to withdraw herself from the company of the respondent at a matrimonial home. Hence, the petition is not maintainable.
One submission, Your Lordship. With respect of only maintenance, they have made the observation. Since he is getting 5,000 of maintenance in BBI, and also husband has
No.
produced a salary certificate.
Under 125
Please,
CRPC.
they should not have mentioned the reason for the.
125.4 she has dismissed it.
Please, Your Lordship.
And the court has also observed that the material placed before the court indicate that she is opposed to graduation. She does not have any infirmities to earn money. And the take-home salary is rupees 17,909. And inter-maintenance of 5,000 she is receiving in domestic violence case. And the remaining amount is 12,909. Hence, the wife is not entitled for maintenance. The the penultimate paragraph, it is stated that she has failed to establish that she has sufficient reasonable excuse to withdraw herself from the company of the respondent husband, the sufficient income of the respondent husband. Hence, the basic ingredients of section 125 CRPC being not proved and established, has dismissed the claim of the wife. Land counsel appearing for the petitioner submits that the court has failed to consider the application in its proper perspective, and the reasoning given by the court is contrary to the purport of 125 CRPC. And the court ought to have granted maintenance. Next part. Land counsel appearing for the husband submits that the court had already observed that the husband is paying an amount of rupees 5,000 towards maintenance, and the remaining salary is 12,000.
Please.
Remaining salary is 12,000 and not. The court had considered the case basing on the material available on record, and no.
ते कशाला बघतील ते तेवढं
बरोबर आहे त्याचं पेमेंट आलं ते करणारच नाही
और जरा गाड़ी सीधा लगा
ये बंद कर छोड़ा बाजी बाद में देखेंगे शाम आगे गए रहता
इधर बोलो त्याला मला बोलायचं
कॉल फॉर
सर ना बोलो
from this court. Next paragraph. Having heard the counsels on either side, produce the material on record. In the Domestic Violence Act, the court, considering the evidence on record, has granted maintenance. But the manner in which the court has proceeded and held that there is no sufficient reason for the wife to stay away from the husband. Such a finding cannot be, is not tenable, and it cannot withstand the legal scrutiny. As far as that aspect is, and that observation and that finding of the court needs to be set aside. Then coming to the quantum of maintenance, both the parties are at liberty to file their respective statements of assets and liabilities before the court and adduce their evidence. Basing on that, the court shall consider the same and pass appropriate orders. Accordingly, the court is passing the following order. Number 1, the order impugned in so and so is set aside and the matter is remanded back to the trial court. 2, trial court shall consider the shall consider the case of the wife for grant of maintenance after considering the statement of assets and liabilities by both the parties and after considering the evidence accused by both the parties. The parties, without further notice from the court, shall appear before the court on November 25th and within 15 days from November 25th, they shall file their respective statement of assets and liabilities. Thereafter, within 4 months thereafter, the court shall decide the application.
Yes.
Before the family court of 5,000 implementation has been awarded that may be continued because the domestic
But whatever has to follow. This court will not.
Domestic violence and both 5,000 has been awarded. He is deciding an armed possession of still he has not paid any IRS.
That you move an appropriate application to the court. Yes, next. Huh? 92 who appears? 92. This is a matter 92. Yes. Any pass-outs? Yes.
Serial number 43.
20?
Serial number 43.
1 minute, 1 minute.
44.
44.
44.
First matter I am appearing for petitioner. Second matter we got the appeal. Notice is not a then I take notice, my lord, and matter will be referred to the mediation.
44. Mr. Shivraj P. Muddol is directed to take notice on behalf of the respondents. It is submitted that there is a likelihood of settlement. Both the parties shall appear before the mediation center on 19th of November.
Second matter.
Huh? That's what I said. Yes, next. 70. One minute. No, in 76, if party has taken the file, you have to file a memo. What has happened to 76? Huh?
20th.
For dismissal? For dismissal? On list this matter same day, not on dismissal. Petition, it is submitted that the party has given up wakalat. He'll come up with an appropriate memo. Yes.
Humble prayer, my lord. My lord, in serial number 80, please extend stay order, my lord. We can give it.
Interim order is there.
Yeah.
In 88, in that matter.
80, my lord.
80, if interim order is there, extended. Yes. 20?
29 minutes. Needful has been done, minutes.
29. Then council submits that the needful is done. We'll have it on Monday.
Weeks ago,
It is submitted. Needful is already done.
The deficit quote has been
Then
notice has to go, madam.
no, it can go, but it has to be heard for the first time.
Please.
Suppose this matter, the council submits that the needful is done. List is already notice is ordered in 29.
No.
Notice has been ordered on 19/3/2024.
List this matter after service of notice. Yes. Then council submits that needful is done. List this matter after service of notice. Yes. Any other matter? Select signatures because there may be some variation. We'll sign it later. 40? Yes, it is there. I gave the date also. It is on 19. No pass-outs.
No.